So now we're on to section 3. I hope you all enjoyed the movie, Desert Cloud, a very old movie. After trying to apply Desert Cloud in architecture and planning in various countries around the world, I got more interested in the information transfer itself, how to communicate through art to persuade politicians to stop global warming. The first thing was how to put the materials, energy, and information into the architecture to enhance the experience and enable participation. I gave this paper at the 1977-78 European Conference on Architecture. Innovative passive retrofit to a public building, an informed architecture. So this is the first reference to information in the architecture. I gave a talk at the Barbican Centre in Cambridge University School of Architecture on information architecture rather, informed architecture. And I'd also been working with Professor Richard Gregory on designing the Bristol Exploratory for interactive science exhibits. The Science Museum made a launch pad with a similar idea. This, in fact, has started with the brother of Dennis Oppenheimer, Frank Oppenheimer, when he was evicted from America by his brother, claiming that he was working for Russia. He came to England and he was walking around the Science Museum and he saw this little demonstration model and thought that was a great idea for explaining physics to children. And basically, interactive science exhibits come from that idea by Frank Oppenheimer. And the San Francisco Museum is dedicated to that kind of art. And I think they have my waterbed in that museum. The paper proposed using the interactive design, computer-aided design, and incorporating the design process, interactive computers, into the building itself, so that the building will know how to perform. So in 1984, I started working with Professor David Bohm, Professor of Theoretical Physics at Birkbeck College. He was the last person to work with Einstein, basically. He lived in Princeton and tried to solve the contradiction between quantum mechanics and relativity. If you apply one to the other, you get an absurdity that as you get infinitely small, you get an infinite amount of energy. And this is how the two theories are incompatible. And he worked out a theory of what he called the implicate order, where the world was created out of nothing. And so I devised this exhibition on nothing using his quote of the creation of the universe and also a quote by Leonardo da Vinci, saying words to the effect, of all the greatest things in this world, I'll quote it from the exhibition catalogue. Among the great things which are found among us, the existence of nothing is the greatest. This dwells in time and stretches its limbs into the past and the future. 1452 to 1519, Leonardo da Vinci, and with David Bohm's quote. So I had an exhibition with blank canvases and or blank screens on televisions with just the formula for quantum mechanics and relativity, two most famous equations. And the year we began working in 82, I took him to talk to my students at the Polytechnic School of Architecture. And in 1984, as a tribute to George Orwell, I used the word nothing, which can be read in different ways as no thing or nothing, which characterized the difference between the Newtonian view of the world and the quantum view of the world, where Newton saw objects in space, basically, but Newton the world of Newton is very different from the quantum reality of Einstein or Planck, where energy is everything and space-time are connected in a continuum. And so, as Einstein said, if you take everything out of a room, people imagine that it would be empty. But if you could actually take everything out of a room, there'd be nothing existing at all. The space and time would cease. This is obviously a very different conception of reality, and it goes from object-related reality to the kinetic view, which is trying to express that continuous movement of reality. It was a very interesting exhibition, including I had a catalogue, this catalogue, with a very dense text and previous work coming out of air. Obviously, air in a way is a void, which is empty space. But in it, I predicted that there was a psychological response from some people, which may be one of horror and a kind of panic into the void. And this actually happened with someone appearing at the entrance of the exhibition. And when they understood, as it sank in, they screamed and ran away. So it's extraordinary. I mean, obviously, this is the only person who did that, but other people sat and read the catalogue. But this brought out the way there is a physical, emotional response to the work. And the catalogue is just every aspect of nothing that I could think of, but obviously it's infinite through to informed art, where I conceived of sort of noetic art, which, as opposed to a phenomenal art, works inside the brain. So it's this proposal in 1981. And the Pompidou had a group show on nothing, which was, I always see as the most avant-garde catalogue. There are about over 100 artists who'd all done something on nothing. I was writing the entry for the catalogue on the day of the crash, the financial crash in 2008. So I pointed out that capitalism is based on nothing, just the confidence in the figures that the piece of paper will be worth and redeemed for the value. Halfway through the 90s, I still wasn't getting through to the either the fossil industry or government about the importance of global warming, and decided to read law to find out what the law of the environment was. And it just so happened that the Brunei Gallery, which the Sultan of Brunei had given me 10 million pounds, 10 million pounds to build at SOAS, was being constructed on the opposite point of the quadrangle. So in the quadrangle, in the photograph, you see Birkbeck Library, and there's Brunei Gallery on the other corner, SOAS on the other corner, and Senate House on the other corner. But it ran into big trouble. And it was, in fact, stolen by SOAS as a project. And so I was watching it being built after it had been after I'd been abandoned by law. The law refused to protect. So I did a 4-year law degree, and then went to the Inns Court School of Law to do the bar exams, which for another 2 years. And this is quite an experience to be taken into the body of the law. There's this temple round church in a temple inn of court. There are 4 inns of court for the barristers. And so you work in the library and in the school. And they have one of the oldest round churches. There's only a few of them left from the 11th century, with the Knights Templar buried in the crypt. So, and this is where I connected with the Nothing exhibition, as the law itself is based on nothing ultimately. It's the power of making something out of nothing, text or image, becomes the prerogative of the sovereign, the spiritual man in general, the true pneumaticos. Pneumaticos being full of air, which meant spirit, and that was the ultimate authority. And in fact, the vicarious power of the priest, the church, came from God out of nothing in the same way. The Inner Temple Law Library, this is where you can feel in the body of the law, learning to state right or speak law. as a judge. So it's a changing your position completely in being able to have the authority of the law. In a way, it's directing the signified from the signifiers. So everyone sees the same signifiers, but the signified is obviously an infinite choice that comes from the person, comes from within the person. The person themselves, depending on their individuality, chooses the signified. And I would say this is the reason that AI is not all it's cracked up to be, because AI is based simply on copying. And there's no way the AI machine can reproduce the decision to choose a reality or the signified from the signifiers. Or it's not going through that process at all. It's simply looking for signifiers in mountains of text and finding similarities and matching similarities from pattern forming. Well, that's fine, but it cannot produce an original idea because it's copied. And no matter how much it's copied to infinity, it's still not producing something new. This is a fundamental aspect of copyright. The artist is sovereign of his own works, just as the king, like the handing over the spear is a symbolic act, handing nothing but handing the sovereignty to the king, or handing a sultanate to the sultan. So both the king and the artist have sovereignty. The king has sovereignty over his country, and the artist has sovereignty over his work, which is protected in law by the Copyright Acts and patents, and also the moral law. And then, due to the theft of the Suez Gallery, the Brunei Gallery, I had to actually go to court in 91, which is just across the road from the Inn of Court. It's right in the heart of London. That's the famous entrance for the steps of the High Court of Justice. So in my final year at the Birkbeck School of Law, I did a dissertation on the artist at law, images from a case in transition, under the tutorship of Dr. Anton Schutz. And that was writing this concept of sovereignty coming from nothing, symbolically, like handing the spear of the King of Toro or inheriting the Sultanate of Brunei, or materially through creation from nothing by the artist. And this is from Ernst Kantorowicz, 61, The Sovereignty of the Artist. But then Lacan describes in the mirror image stage of every human being's development an identification, the transformation that takes place in a subject when he assumes the image, an image. So this is the art experience that I was trying to reach, the experience of reality, and changing that from contemplation to action and active experience, like walking on water or bouncing on a castle, bouncy castle. And that's Jacques Lacan in 77. quoted in one of the books of our tutors, Peter Goodrich. Now that is the basis of the artist's ownership of his property, which is equivalent to the ownership of land or any other property, and is protected, has very, very strong protection in law by copyright, patents, and the moral right to be known as the author of the work of art. If you create something, you have a moral right to be known as the author of that work, and it's completely independent of quality. The law does not distinguish quality in any way in giving the protection. Whatever you create, you own. It's yours. It has nothing to do with the law. But if someone copies it, then you are protected from someone copying it. And of course, this is extremely relevant at the moment where AI industries are trying to copy the whole of the BBC, for example. And the BBC is having to go to court to protect all the artists that it broadcasts. And it's interesting, the corporations are arguing that the BBC don't understand the technology and they have a right to copy, or they should have a right to copy. And they're asking the UK government to change the law so that they can scrape all the BBC material for the training of their AI machines. But of course, in law, this is against the law. It's against the copyright. They do not have the right to copy. Just as Zuckerberg did not have the right to go against the privacy laws, which he changed by himself by simply announcing there's no such thing as privacy anymore. Well, he doesn't change the law. He has no authority to change the law. The law can only be changed by the government. And so there's a huge amount of infringement at the moment. But it's very difficult to pursue in a lot of cases because of this mass copying, the scale of the copying. But the scale doesn't change the law. It's like a bank robber saying, well, I can't afford to pay the fine for robbing the bank, but you have to let me rob the bank still. I mean, if they can't produce their products because it'd be too expensive, then it's economically non-viable, so they can't produce the products. And there's a saying in case law that the seller's word is not enough. And that is the argument against the AI industry stealing everyone's copyright. And it's not only for artists, of course. The artists are protected for copyright of their works, but data could be seen as a similar property. Data itself is a property. And is it in danger of being given to Palantir by the government or sold at a very low price because the government don't understand the value of the data, whereas the company does. And the company is in a fundamentally different position of being a seller of goods. And so it's bound to say things to advertise their product. And it's well known and accepted that advertisers can use what is called in law mere puff. They're exaggerating the quality and performance of their goods in order to sell it. This doesn't change the law at all, of course. So that the seller's word is not enough. Is it enough to stop the government giving all the BBC's artists work for training of AI machines? The Brunei Gallery is finished, and this plaque was put on the side apologizing to the owners of the land. They had obviously failed to inform the landowner, so they hadn't gone through the procedure correctly. And then they'd stolen the project. So it compromises the UK honour system, as public bodies should uphold the law. So to award the Civic Trust Award to a stolen building compromises them, but it also is an insult to the Sultan of Brunei by not building his gift as he directed. He gave me the 10 million, and he said, "This is a wonderful proposal you've made, you've drawn, and with the text and drawings of the proposal." And he said, "Well, this is fantastic. I wish every proposal was done as well as this." So he obviously wanted us to build it. And so that remains in the court over the issue of copyright. This is a project in 2015 to design a micro-macro biome. Using the placenta of the female body as the critical interface, the only interface between living organisms, which is a physical interface, and carries the function of exchanging food and energy and filtering all the pollution that from the mother to the child, which of course with a lot of modern pollutants, it doesn't filter and can damage the child in the womb. And so this was taken as a metaphor for the critical state of the environment. If babies are being damaged in the womb, the pollution was extending into the womb and out into the atmosphere from the micro environment of the body, the womb, into the macro environment of the macrobiome in polluting the atmosphere. And Professor Eric Jonio is a professor and the leader in the field, working on transmission of babies in the womb, particularly with sound environments. But that again ran into problems. So at that point, I began to wonder whether the embeddedness of the fossil thinking is so all-pervasive that that is the main problem why we're not saving the planet. It's because people are trying to sell oil, and so it's a commercial operation to keep the industry going. And the fossil industry is very loath to transition into renewable energy simply on commercial grounds. So we need a law. It has to be done by law, I think. We have the agreements, the international agreements like the Paris Agreement, but they're obviously not strong enough to persuade people to apply the technology to change the policy, the government policies. So if we go back to the beginning, when the MI5 started monitoring me in '67 by arresting me, I don't think they had any idea about global warming. it was simply that I was unaware, we were all unaware, all us artists unaware of the military history of air structures. And I think that the the time people were very aware of the Philby spy case with Russia. Um, Gustav Metzger, who organized the Destruction Art Symposium, he was a member of the Committee of 100 with Bertrand Russell. So I think the security services were just worried about all artists, basically. So they started following 5,000 people to find out what was going on. I was interrogated for 2 hours in Scotland Yard without any reason given, and then detained by the Dutch when I was by the police when I was with two Dutch curators. After looking at visiting pavilions in the park, we were stopped and taken to the car pound of the police station, and they dismantled my car, presumably looking for drugs. Yeah, so I was just going through reviewing my whole career about just how because I only found out that MI5 was monitoring me in about 2003. So it's a pretty big shock that your stuff has been monitored and actively worked against. Uh, so this is a list of all adding up all the different things. But what it shows is how the secret services are so embedded with fossil thinking that they don't conceive of renewable energy as anything else but some kind of subterfuge. And I had a meeting with Tony Benn, for example, when he published his last version of his memoirs. And I asked him why, what was just the general attitude of politicians to the green movement. And he didn't answer for a long time. And then he said, well, I have four things to say about the Green Party. And I don't remember what the four things were, but what was obvious was that the Greens were simply an alternative party, and they were the opposition. So therefore, they had to be argued against. And this was why they weren't being taken on board, because power was provided by the fossil industry. That was why every prime minister is taken up to the North Sea, put on an oil rig, and explained the world of power and fossil energy. And we're totally dependent on the North Sea for our wealth. And so the Treasury has to operate under that mandate. And this is a very serious change, as big as a change of going from Newtonian physics to quantum mechanics. And it's an understanding of reality that I seriously think that many politicians cannot understand. They do not conceive of how the planet is going extinct. They can't conceive of it because they don't understand enough of the processes at work to understand that the gases are changing in the atmosphere, so they have an increased capacity to store heat. And this is just continuing in a very simple relation. The more carbon dioxide we put into the atmosphere, or methane, the hotter and hotter it gets. And it's just going on. It's not going to stop. It's never going to be reversed unless we take some kind of concrete action that has to be extremely carefully considered to reverse the 40 gigatons or whatever of gas of carbon we're putting into the atmosphere. There's some 500 gigatons has been calculated that we can still put in without going past the point of no return. That was in 2020. Now we're down to 120 gigatons of carbon to be put into the atmosphere before the point of no return. Of course, these are very not inaccurate, but very broad calculations. It's extremely difficult calculation to do. But that gives us 3 years to reverse global warming, to take out the gases from the atmosphere. And this is the technology that we're trying to communicate to politicians. I had actually declined some Ministry of Defence funding for the wave tube and hover tube back in the 70s, because I didn't want it to be military technology, which is definitely a mistake on my part, I think. I should have signed the Official Secrets Act even, which meant that I would not be able to communicate, would have no freedom of expression. And this is the reason I did it, is because I wanted it to be a public art. As Lord Denning said, art by its nature is in the public interest. Whereas military technology, by its nature, has to be secret. You lose your advantage if the other side knows your technology. But the main proof was in 77, 76, when two MI5 agents came to the meetings of the International Solar Energy Society. And my professor noticed there were two smartly dressed people coming to every meeting, but never engaging with people or asking questions. And so he went up to them afterwards and said, it's very good to have two such loyal members, but you never ask any questions. And you don't even take away the proceedings. So do you mind telling me what your interest is? And they said straight away they were from the MI5, and that my work, Desert Cloud, is obviously against the economic interests of the country. Obviously against the economic interests of the country. Fortunately, my professor knew my work, so he was able to say, well, it's a free country, so what? But he was still felt bound by the Official Secrets Act not to tell me that of my being monitored, which is the law, in fact. Even your MP is not allowed to tell you that you're being monitored by the secret services. But of course, Shell and BP were also founder members of the society. And so it's quite feasible that they were working with MI5 agents. But this, of course, would be against the law, because the mandate of the secret services is to work in the interests of the whole country. They're not allowed, it's against the law to work in the interests of a part of the country, i.e. the fossil industry, as against the renewable energy industry. And so the secret services, if they are doing this, then they are working against the interests of the country, against the law. So then when in 79, I formed a company with Over partners, with Sir Over himself, as he loved my stuff, and he said, well, why isn't it being done? And so we formed a company together, and invited with Peter Rice. He was the engineer at Over, and KPMG and Deloitte's, Davis Langdon Everest, and a friend of mine, Eddie Shackleton, was head of the Royal Geographical Society and also head of the Lords Committee on Science and Technology. And he invited his friend Earl Jellicoe, who was head of Tate and Lyle, to develop the first application of desert cloud. As we talked about earlier on in section 2. But one of the investors, Gordon Edge of the Pat Centre in Cambridge, had said, well, after all the others had agreed to come in, including Rothschilds and Prudential, Sir Jack Lyons, Chernogly's, and Southern TV, he said, this may be the holy grail we've all been looking for. But we better check it out in the Pat Centre, which is a Cambridge research centre for exactly deciding what new technologies would be a threat to existing technologies. And they produced a report within a couple of months saying that it was, it did all it said on the tin. So that was the basis of forming the company and raising the money. The European Commission were going to, wanted to invest, but they said they didn't have enough money. But by coincidence, the French greenhouse technology competitor for greenhouses was on the funding panel, which is neither here nor there, I'd say. But so that was the kind of blockage we were getting. In the Seville World Fair, the structure I showed with the dynamic solar lenticular pillow working on the sun, a static lenticular pillow was actually built for the, I think it was the German pavilion. In Saudi Arabia, we specified optically selective membranes for the Hajj walkway shade structure. But it was actually built, I think it was taken over by either Bin Laden's or Darul Handisa. And this metal decking and extractor fans were for 7 kilometers. The work in Africa, I contacted the Department of Overseas Aid, and they said simply, we have our own plans for Uganda. A very curious incident. I met an officer of the Energy Technology Support Unit at, called ETSU, working out of Harwell, who was a government organisation for funding renewable energy. And he said, well, I'm dying, so I can tell you what my job was. And he said, I am paid to select projects which wouldn't work and fund them. And I have to write the criticisms of those that do work, so they won't get funded. So he was a scientist employed to write fake science, basically. So when I get to the court in the Brunei Gallery, Lord Justice Brooke gave and stopped SOAS from appointing another architect. And Viscount Bledisloe, on appeal, said, well, I'll lift the injunction for appointing another architect, but if you're trying to get rid of him altogether, that's a far more serious matter. Referring, of course, to copyright infringements and property rights in the project. That case was in court for 10 years or so. for various reasons. But it's still, I still have leave to appeal so against SOAS on copyright, and the other project as well, the Islamic Priory. There are two projects. But as the Times Law Report states, the judge ruled that the power to stay the action was not unfair, and until I paid all the costs into court of the previous action. I had already paid 5,000 into court. I then began working with Polly Higgins, who's writing a book about the corporate and political practices destroying the planet and proposing the laws needed to eradicate ecocide. And this is the first effort, I think, to bring the law into actually stopping. I mean, the UK is very advanced, of course, in renewable energy, and it has the Climate Change Act. The European Commission, European Union has climate change laws incorporated in the the various acts, the environmental acts, the wastewater treatment directive, for example. But again, I proposed a blue-green infrastructure meeting at the Royal Society with all the renewable energy technologies, including my favorite, which is taking the carbon directly from the atmosphere, producing it's this project at Cambridge University where a 40-foot container has a reactor which takes carbon directly from the atmosphere, produces 1 megawatt of energy, and takes 150 tons of carbon from the atmosphere in the form of pure graphene by simply using all the waste. And then we have the 2014 Secretary of State's decision for granting development consent to the 4 billion Thames Tideway Tunnel, which we then argued in 2015 that this is against the Climate Change Act. And in the meantime, the microbiome had been refused funding by the Wellcome Trust with the assessment by the judges of the application that the 1898 global warming calculation was irrelevant. This is Aarhus's calculation. If you double the carbon in the atmosphere, the carbon dioxide in the atmosphere, then you would get a 4 degrees centigrade rise in temperature. And secondly, they said, well, biome is not a term of art, so we can't really fund something that's not scientifically valid. But I think that's fairly obviously fairly weak excuse for not funding the program. Of course, the High Court refused to reopen Blue-Green London Plan versus Secretaries of State for Climate Change and others. After I appealed to reopen the appealed case. Now, I think I should tell the story of I was completely sidelined in the court by the sophistication of the arguments. But I was coming to the end of my arguments in court before Lord Justice Ouseley, Mr. Justice Ouseley, I think. And he said, well, I have to say at this point, Mr. Stevens, I tend to agree with you. I'll give my judgment after lunch. And after lunch, the Secretary of State, QC at the time, stood up and said, my lord, we have changed the law over lunch. And what they had done is they had taken my argument and taken it to the drafting office in Whitehall and put it into the Criminal and Civil Procedure Act 2015, I think. And so, which had already been passed in Parliament. So they inserted my argument into the law. So my arguments are now part of the law, part of the Constitution, and on the same pages as decisions by Lord Denning, etc., which is extremely satisfying result to me studying the law and taking the case. Of course, the judge said, well, it doesn't really help you because you can't, the law doesn't act retrospectively. And so the ministers of state are allowed to make mistakes. So that is how the case for building the blue-green version of water treatment has still yet to be heard in the court. And then in 2018, Margaret Thatcher's papers were released using the phrase, ensure they don't succeed. And she was her Minister of Defence, I think, was one of her Ministers of Defence was Earl Jellicoe, who was became chairman of Tate and Lyle. Then in 2018, the Royal Society had a 2-day meeting on biomes covering micro-macro biomes. Okay, so in 2009, Thames Water made a proposal to the government to build a tunnel, which would affect rebuilding in front of my house in in Putney, on the Putney embankment. And so I had I was called what's called an interested person in the case to make objections to their building. And we formed a group with Justine Greening, and I formed a group with experts, a blue-green independent expert team, to examine the need for the tunnel. And this first meeting took place in 2010. And we met regularly with Thames Water. Thames Water offered to fund us to take part in the public participation of assessing the tunnel. So we got heavily involved in the whole thing with 2 other organisations, Thames Bank and Thames Blue Green Economy. And we had meetings in House of Commons, House of Lords, Hammersmith Town Hall, and we used to meet regularly in Putney Rowing Club, Sailing Club. And then, but the minister went ahead and made a decision. In spite of us having an alternative blue-green plan, which we wanted to be examined with the same budget as the tunnel proposal. They spent something like £600 million on the feasibility of the tunnel. And we suggested they should spend an equivalence on the blue-green technologies, which were new technologies. This is the point in law, is the minister, if there's been a significant change in the technology, then the national policy for water has to change to adapt, to always use, to ensure that, according to the EU law, we would always be applying, in schemes such as this, the best available technical knowledge, not entailing excessive cost, which has been abbreviated as BACNIC. So the best available technical knowledge, not entailing excessive cost, we thought was blue-green technologies, about 30 or 40 different technologies for simply redesigning London to develop, to be resilient according to the Climate Change Act, to deal with all the issues, and not just the one the Thames Tunnel addressed, which is the overflow of wastewater. When it rained too much, then the sewers flooded, and the overflow went directly into the Thames, polluting the Thames. And the tunnel is a proposal to take the overflow, instead of taking it out through what's called the combined sewage overflow, is to take it directly into a massive tunnel that went from one side of London to the other, 25 kilometres, costing £4.2 billion. And we said the alternative technologies could do it far cheaper, far quicker, and be 10 times more beneficial to London, for greening London, making it climate change resistant, but also beginning to reverse climate change by planting trees and so on. This is done with bluegreenuk.com, is Professor Darren Wolf's website. As you can see at the bottom of the screen here, bluegreenuk.com, which you can look up all the work that we did over a period of 10 years or so. But after the judge refused to allow us to argue against it, they changed the law, and this is can be referred to in the Queen on the application of Blue-Green London Plan, as Graham Stevens was Secretary of State, states for Environment, Food and Rural Affairs and the communities and local government. So it went to appeal as well. But the situation was still the same, that pollution is increasing, emissions are increasing, fossil energy is still increasing, and we're getting nearer to the point of no return, which on the present calculations of the best available technology, not intending excessive cost, is that we have 3 years to substantially reduce the carbon in the atmosphere. So we remove the carbon from the atmosphere, as well as lowering the emissions into the atmosphere. So we have to do it from both sides, lower the emissions and take more out of the atmosphere. Otherwise, we're at the point where we'll reach the point of no return. As calculated 3 years, but it may have already started. I did a work called "The End of the World Has Begun," which was simply a photograph of the Greenland ice sheet, the official photograph by the Royal Geological Society, with a text describing how it was always thought that rivers of meltwater formed on the surface of the Greenland ice sheet and formed what they call moulins to pour down to the bedrock underneath the ice sheet and out to sea, giving a melt time of hundreds of years for the Greenland ice sheet. But then some scientists actually went in a couple of years ago, went down one of these moulins and found that the water was not going straight down to the bedrock, but was forming infinite numbers of channels and even lakes, internal lakes, in the ice sheet itself. So solar warmed water is now embodied in the ice sheet, and there's just no way of getting it out without the water melting the Greenland ice sheet. So that has been designated by scientists as the first point of no return, where there is nothing anyone can do to reverse the melting of the Greenland ice sheet, and it will simply melt within so many days, so many years. Now, as far as we know, we have 3 years, but it's a very vague, inaccurate, or broad measurement. We don't know, for example, whether the melting of the permafrost, which has already started in Russia, in Siberia, has gone past the point of no return. If that's gone past the point of no return, then it may be all over. We don't know. But people are very reluctant to say it's all over, I think for political reasons. But in discussion with James Hansen, the head of NASA, who told the Senate committee in '88, I think, that global warming was a fact. When they invited him back 20 years later and asked him if it was a fact again, he understandably said, "I told you this 20 years ago and you have done nothing." But he uses the analogy of Venus, which has the same quantity of carbon, but the only difference between Venus and the Earth is that in Venus, the carbon is in the atmosphere, whereas on Earth, the carbon is in the Earth. And we're now pumping the carbon from the Earth into the atmosphere. And Venus, of course, is now at a temperature of 600 or so degrees centigrade. So it's extremely urgent that we reverse global warming and stop emitting carbon or methane or other greenhouse gases. This is statement 13, which is a way of an image of the damage that the fossil fuels are doing by emitting greenhouse gases. The effect in towns is that they form a gas chamber effect in the high streets, where it concentrates the pollution and trapping the particulate matter. And of course, it affects children's lungs more than adults as they're lower and nearer the exhaust fumes. and are more sensitive to the pollution. And this is all against the law. But the problem is obviously how to persuade the lawyers to implement the law, and how to persuade the government to make the right policies to make destroying the planet against the law. So the idea, I mean, obviously we have had some success in communicating with politicians. We were invited by the Secretary of State for the Department of Environment and Rural Affairs to participate in the rewriting of the National Policy Statement for Water. But that turned into, at the time the minister was Owen Paterson, and then it became Liz Truss, and then it became Nigel Gove. And it became the new Environment Planning Act. But Michael Gove then tried to change the constitution in the Planning Act to make it more difficult for people to take the government to court in judicial review. So this is the battle between the government and the law against the constitution. Our constitution is specifically formed by the sovereignty, the sovereign, the law, and the executive government in order to balance the powers. And this battle between the government and law and constitutions, national constitutions, is happening in several countries around the world at the moment, where the populist parties are trying to get rid of the law, the legal powers. And the legal powers are there for a very specific reason of balancing the powers of the executive. A friend of mine, a psychoanalyst, Jean-Gerard Bernstein, wrote a book on the psychoanalysis of the Bible. And he points out that the Ten Commandments, the original law, body of law, is formed for the purpose of the survival of the Jewish race. It's not simply, you have to apply it for it to be effective. And so the problem of non-enforcement is the biggest problem. We have the Climate Change Act and we have many other laws that if they were applied, they would have been solving the problem. In 2016, I got an invite from the European Commission to visit their joint research centre in Ispra in Italy, where they have a wonderful research centre. And the head of the commission explained to about 20 artists that this wasn't a publicity exercise, or because the European Union has a real problem of with the science. They have 11 science centres in the European Union, and they're doing all the research necessary for global warming, including global warming. But their problem is that the politicians simply aren't reading it and fail to make the correct policy for enacting the protection of the planet, which is clearly a security issue. The biggest security of the planet is existence. If we don't solve the problem, we are going extinct. Um, so they designated me a Psi artist, an interdisciplinary expert on science and art, on their portal of experts. So they also forwarded my case against the Secretary of State for the tunnel. They forwarded that to the task force for negotiating the UK's exit from the EU under Article 50, Brexit. So they forwarded it to Monsieur Barnier, not to the UK committee. This is the call to act I made to the European Commission for them to act against Brexit. Because it was clear that in the Miller case, when Brexit went to court, in the High Court, Mr. Justice Neuberger told Theresa May that she didn't understand the Constitution, that she wasn't allowed to ask to exit the European Union except in the procedure set out by Article 50. So that produced the act. Theresa May questioned the court and went back to appeal and had to be told again that she didn't have the power and had to make an act. But throughout this process, nobody was reading the Article 50, which said that the European Union, anyone can leave the European Union according to their own constitution. So the only thing you have to do if you're leaving the European Union is to follow your own constitution, that is the UK constitution, which I don't think anyone would claim that we followed our constitution. We didn't inform the people what the consequences of exiting were. We didn't explain all the expertise, and in fact gave misinformation about the effect of exiting the European Union, and had a completely unfair trial, referendum rather, not trial, in which 52% of the people said it was an unfair referendum. And so the law is that it is the politician's job to assess the significance of the vote. This is not necessarily to follow the vote. It's an advisory referendum. And so there was no must about leaving the European Union. It was still up to the politicians as to whether it was in the best interests of the UK that we should leave the European Union. And if they decided that it wasn't in the best interest of the UK, then all they had to do is simply say, we withdraw from the procedure, and that's the end of it. We don't have to get the permission or have a referendum. None of the other members of the European Union can object to us remaining in the European Union. We only have to withdraw from the process, which is an extremely simple process, obviously. But that piece of vital information was never discussed in public, as far as I know, in spite of me trying to get it discussed. And this is what I referred it to the European Commission to try and get them to act on making everyone in the UK aware of this fact that it's very easy to simply remain in the European Union throughout all the years of negotiation. At any point, we could have simply said, that's enough. We're staying. It's not in our best interests, which I still think is the situation under the convention, which I have put in all the law the papers. So the scale of this destruction to the UK economy relates directly in political science terms to the End of Times book by Peter Turchin, Elites, Counter-Elites, and the Path to Political Disintegration. From big data analysis, all civilizations in history have ended when the mass of the population realized the elite in power have created what he calls wealth pumps, to pump the wealth of the poor to the rich. So one has to ask, in the current situation, if we're living in a plutocracy, a kleptocracy, or democracy. And this is the first piece of success I've had with my environmental art, I would say, in communicating with politicians. This does satisfy the Commission from the European Union of persuading politicians of the seriousness of the climate change. And I would say you could describe Ed Davey, he's the leader of the Liberal Democrats, falling into polluted water as a performance of water plank. Of course, he made no reference to me, but they did use 3 of my works. I mean, here there are 2 works combined, the water plank and my case for blue-green plan against SOAS, against Secretary of State for the Environment, Secretaries of State for Environment and Communities. So the signifier would be the water plank, and the signified, he's interpreted this and made his own interpretation. He's participated and made this performance himself of falling into the water. So the image very effectively communicates the undesirability of falling into polluted water. And so this got a huge amount of response and was very well understood of the impossibility or the difficulty of walking on water. And the unlawfulness of polluting the water, which is by then had gone from polluting the Thames to polluting just about every river in the country. So this is, from an artist's point of view, this is extremely interesting point as to when it actually connects and communicates with the minister. And no one could produce this as a performance. And this comes under the category of copyright, for instance. I don't believe any AI machine could devise this performance it's an original performance. It's never been done before, and it couldn't be thought up by an AI. What AI can now do is copy this and try and find similar things to do, maybe. But it would only be copying and should be credited as copying. But is the basis for not giving copyright or waiving copyright on behalf of all the owners of copyright to corporations who are simply in the business of making commercial profits, and will the seller's word is not enough as to their performance. They cannot invent art, originate art. They can only copy it. And so the copyright shouldn't be waived for AI machines. And it's such a fundamental basis. I mean, property ownership is the basis of the whole civilization. So the form of the work, Blue-Green London Plan. So this is the website of Blue-Green UK, run by Professor Darren Wolf. And it includes the whole case. So the case is published and can be referred to online. And this is the call to act to the European Union, setting out the law and the history. As you can see, it's extremely complicated. And I'd also, AI, of course, can be of great assistance because they can copy the law and they can present the law, but they cannot make the decision because the decisions are so infinite. In law, it's called in all the circumstances. And AI cannot consider all the circumstances in terms of the human. It can only do it from the machine. It can only produce copies. It cannot produce human decisions. It has no feeling. So this goes through, recites all the wrongdoings of the UK in water, and also the Vienna Convention on the Law of Treaties about how we can go back into the European Union. And how any natural legal person can make an objection and a call for action under this is under Article 191 about all the things that we should have been doing, including paying particular attention to worldwide environmental problems, and in particular combating climate change. So the European, as a civilization, has a duty to combat climate change. That's as far as we've got a duty to combat. So out of all this law and masses of information, then as the artist, I select one particular day, which is June the 15th. Uh, 2015, and point out to the judge, after dealing with the matter in hand, I ask that with permission, the skeleton argument humbly invites the court in consideration of one short but important point of statutory construction, which is what we were next dealing with. We celebrate the continuity of principle established by the Magna Carta on this day, this very day, 800 years ago, and continued into the Aarhus Convention for participation in law, Environmental Impact Directive and European Convention on Human Rights, for example. The right of access and participation in judicial procedure, including Batnik. And that this action against Thames Water mimics exactly the same political action that King John was trying to do in taking the water rights of Londoners in 800 years ago. So as an avant-garde artist, I take that one page, make it into a legal document, and insert it into the law. So this now is embodied in English law, in the Constitution, and has has changed the law. So I consider that as an avant-garde artwork. So this year, on the 15th of June, 2025, which is now 10 years later. So we can take the Financial Times of the 4th of June in 2025 and just add this information into the work, because it is now making itself as a work. It's a story of the Thames Tideway Tunnel. So what has happened since the case is more or less as we predicted. It hasn't solved the problem. There was no need to build the tunnel. So they wasted up to 20 billion. It says in the front page of the Financial Times that the debt is in the order of 20 billion pounds. I'm pretty sure it's on the front. The 20 billion figure is on the front page. But the point is, this is simply the Financial Times were reporting the case as it went through, particularly Martin Blakelock's financial input into the frauds going on within Thames Water. And so you find a similar case recently where the Serious Fraud Office probes the group that sold solar scheme to Thurrock. And this is a far smaller sum, but also starting in around 2016 and 2020. And then it goes on to the dire straits that Thames Water are in, and the politicians are actually calling for the creditors who have heaped billions in debt onto the company should now pay to sort the mess out. And it continues on the back page with recommending taking it back into public ownership. So that's the information that's added to the work in the terms of a public call to act to the Serious Fraud Office. So I'm not engaged in it anymore. It's handing it over to the Serious Fraud Office to ask them to reopen the case and investigate it. as a significant. So the signification they have to take from the signifier of Thames Water is a significant enough case of fraud against Londoners, contrary to Climate Change Act 2008, by increasing the water poverty. So they are have made one of these wealth pumps that Peter Turching is talking about, where the wealth of the poorest in the society is pumped up to the richest. And that is what Thames Water were doing. They were in the form of debt. So that is the new chapter in the work. So this is the final image. As to what is actually being communicated in this image, as in all the other images, the the job of the artist is to provide images that people identify with and can see a future and feel better. It makes them feel good. But it's doing it in a different form altogether. But I would say this does actually communicate with the politician, obviously, that he's accepting, he's taking on the image of sliding down a bouncy castle slide as an image that he can communicate with his electorate and is very effective, as it's been shown to work. So again, this refers back to the functioning of the art and the way it's working on the request of the European Commission to make politicians change their policy. And this is giving an image of the issue and how to change to get involved in the environment and construct a clean, healthy, enjoyable environment. Just as Desert Cloud is an image, an iconic image, I would say, since it's now one of the masterworks in Pompidou Metz, along with they have both the films as masterworks in the collection. Images of renewable energy, of how to save the planet, and the Thames water cases are how to create law that prevents us from destroying the planet. With the same with a reasonable degree of urgency. As I say, we only have 3 years left before the point of no return, if that. So that is bringing it up to date as a survey of the avant-garde from 1965 to 2025. And I hope you agree that this is still an avant-garde enterprise of how to make images that communicate to inspire action to save the planet.